I'm Brianna COF, and I'm about to give my speech. Okay, so on August 9th, 2014, in Ferguson, Missouri, Michael Brown was stopped by Officer Darren Wilson, and he was outside of a liquor store, and the officer asked him to stop, but they continued walking. And there was later a confrontation outside the vehicle. 2 shots were fired outside the vehicle with Brown next to the window. And then Brown walked 15 feet away, and officer pursued on foot, and he didn't catch up to him. And then it is said that Brown turns around and starts walking toward Wilson, and then 10 more shots were fired, leaving Brown dead, fatally wounded. Now, much controversy surfaced out of this ordeal. Some say it was because he was stopped from his race. Others say it shouldn't have escalated to that, and that the shots were fired, and that there was no probable cause for him to be shot. My claim today is that Officer Darren Wilson's actions in the death of Michael Brown were legally justified. I believe this because of the following reasons. Wilson did in fact have probable cause to stop Michael Brown. Officer Wilson acted in self-defense, and Officer Wilson's actions were in line with Missouri police protocol. My first point, Officer Wilson did have probable cause to stop Michael Brown. I looked through a New York Times article, and they gave me a timeline of what they say have happened. At 11:54 a.m., Michael Brown and his friend Dorian Johnson left a Ferguson Market and Liquor, and a surveillance camera even shows that they stole a pack of cigars from that liquor store. At 12:01, Officer Wilson arrives at the scene in his police vehicle and notices that Brown fits the description of a man of the convenience store theft. And then he asked Brown and Dorian to move to the side, but both did not comply and continued walking. At 12:02, Wilson called the dispatcher about the 2 men and positions the SUV to block the men and the traffic. They did not comply, and I have all family that are cops, so when someone does not comply and they fit the description of a crime, they are told to pursue them and just, not anything violent, but just please pull over so I can ask you some questions. They did not comply, so he did have probable cause. It wasn't because his race or he was just profiling, he fit the description of a criminal. My second point is that Officer Wilson acted in self-defense. A witness states that witnesses number 40 and number 17 statements from the grand jury testimony state that Brown charged at Officer Wilson even after asking him to stop. And then a medical examination of Wilson indicated that he had swelling and bruising on his face after the altercation. It also supports the idea that Mr. Brown attacked Wilson. And the photos I examined were released by the Office of the St. Louis County Prosecuting Attorney. And then the autopsy of Mr. Brown supports 2 claims. The first claim that he tried to reach for Officer Wilson's gun in the car, and the second claim that he was charging at the end, and when Wilson told him to stop. When looking at Brown's autopsy report, there is a lesion on his right thumb, and there's DNA, Brown's DNA found on Wilson's thigh and his arm, and also outside of the police vehicle of the driver's side of the door. Now, the autopsy, the medical examiner can confirm that he found soot in that gunshot wound in the left thumb, and the soot come from at least 6 to 9 feet away from the bullet casing, and that and I quote, okay, of particular interest to evaluating Wilson's testimony, the location, yes, it was consistent with casings that were found from the gun, and that it would have been 6 to 8 feet away. Other statements claiming from witnesses, witness 40 and witness 17, were that Brown charged at Officer Wilson. The autopsy also shows that Brown had shots on his left shoulder, hand, and then on top of his head. The top of his head, the medical examiner is assuming that you would have to be charging head first in order for the way the bullet hit to hit the way it did, which supports the claim that Brown was charging off Wilson. And then my third point is that Officer Wilson's actions were in line with police Missouri protocol. Missouri's law states that officers may use deadly force if the officer believes this is necessary and that his or her life or the lives of others are in danger. According to a journal entry by witness 40, Brown charged Wilson like a football player and continued moving toward the officer even when he told him to stop. There was also witness number 6, and he's a member of the Ferguson County Police Department, and states that he arrived at the scene and asked Wilson what had happened, He said that Wilson felt there was no other choice but to use deadly force and felt that his life was in danger because Mr. Brown was charging at him. So everyone who would claim that maybe it was because of his race or he had no probable cause, Wilson was legally justified in this situation because he felt that his life was in danger and he felt he had no other option but to use deadly force with a weapon. That's my claim. Other points also found that, the shell casings. Others supported that would, Mr. Brown charged him that there was 12 shell casings recovered from the scene, and 2 of them were located close to Wilson's car, confirming the testimony about him firing 2 shots. And then the other 10 casings were recovered adjacent or behind the path that Wilson said Brown took charging him, and that was consistent with the idea that he was backing up while Brown was charging him forward. And those are my 3 points, that Wilson had probable cause, he acted in self-defense, and he was indeed in line with Missouri police protocol. And that's why I believe Officer Darren Wilson's actions in the death of Michael Brown were legally justified.
All right, Bree, you described the events in Ferguson very effectively at the beginning, setting up the controversy. The fact that the grand jury refused to indict, I think, undermines the controversy a little bit, although I think it would be demonstrable to show that there are still a number of people who feel that it was unjustified, that there was something wrong, that there's been a cover-up, and so I think maybe you could develop that a little bit more instead of talking just about the incident in historical context, continue to talk about it in the way that it is being discussed by people who are agitating on this particular point, and show why it's important to make the position that you were talking about clear. I thought you had an excellent preview of what the secondary points are going to be, so it makes it easy for us to listen to and follow. And as you got to each of those points, you signposted them pretty clearly. It's a little odd to me that you have some of the physical evidence that's being cited in different places in the speech. And sometimes the physical evidence in different places even sounds like it's the same kind of data about where the casings were located, what the distance was between Brown and Wilson, those kinds of things, some of the soot issues that you talked about there. I think you probably, instead of just focusing on the second point about it being self-defense, you need to show that the physical evidence supports the claim of self-defense, and maybe that's where all of that information can then be lodged to make it fit more effectively there. The presentation I thought was very effective. You do a good job speaking to us. Always, because it's a grand jury, we only get to identify the eyewitnesses by number. I do want to make sure that you cite the grand jury case either directly. I don't know if the grand jury testimony is posted. If you got it from the New York Times, which is where you get the description of the events later on, or if it came from the Attorney General's report that was submitted later on. So you do need to kind of identify that as part of the speech. I think that would help. It also, at the end of the speech, it sounded like you were done at one point, and then you put in some more information, and that was a little bit confusing. So, get to the point, summarize, and leave us on that firm point. I thought you did that finally, but after you'd already stopped once, so that was a little awkward. All right, thank you.